that will not change the position. Who date for a career set, that is not relevant. Here the question is, for the first time they introduced a new selection method in 21. The question is, they must give a fair opportunity to all candidates. Those who have not appeared in the gate examination earlier, whether they have been given such opportunity to appear.
That has not been given.
Sir, all three candidates have you stated on affidavit that
even this year,
what is your reply to that?
even this year, just 1 minute, my lord, Inspector Lordship, just bear with me. Even for this year, normally, my lord, the gate is held in the month of February, first week. So the process starts 1 year ago, around September or October. So now in January, my lords, already, my lords, this year the notification is somewhere around April or March or April. Thereafter, they're still not getting that level playing field. The three chances are still not available.
No, the three chances they have, that amended rule 7.3,
Again.
they have modified. The merit list shall be prepared on the basis of the aggregate marks secured in valid gate score. So if you have appeared in one gate examination, that will be taken into consideration.
Normally what happens is, they'll give us the best.
My only concern is whether they have been given opportunity after this amendment.
So only three chances. That is the point.
गोटे तो इश्यू में क्रिस्टलाइज को जाओ बुलो जोन कहेंगे अपन हाँ So you are disputing that no examination.
Sir, judgment.
File an affidavit to that effect.
Sir, judgment pore. Sir, judgment पर cross ହେଇଗଲା. Sir, aberment कौन दरकार? Last opportunity is this gate, and that is one day prior to the amendment. Because how can it be construed as an opportunity given pursuant to the judgment, pursuant to the advertised amendment? There was no rule in place. There was no rule. There was no rule. Again, a rule was not in existence till 30th September. Your rule was not in existence, it stood quashed. Yes. There was no rule in existence in the eye of law. That rule comes into existence origin, that is only on 39th, 2020.
Yes, sir.
And on 29th, the window closes. The gate for gate closes. Gate for gate closes. And where is the question?
Take by the flag here.
Where is the question of giving an opportunity?
State by law, they have been saying that highest mark in the gate. It is not highest mark, it is added gate.
This is at the stage of admission.
Situation remains. Situation remains what it was. Pre-judgment and post-judgment.
All right.
Similar, that flag F, only 1 minute. Flag F.
Flag F.
Yes, sir. Can you see that flag F? You are not getting down. Flag F. Page 25.
You are not affected by your
Yes.
How are you affected? Nobody is dividing your
Only one submission. Only one submission.
Now, fair candidate are trying to out the past candidate.
Our entire case is, now your worship is hearing this matter, worship fixed of a final hearing.
No, kindly come to just take 1 minute. No, you didn't wait. Kindly
Your worship will only say that
repeating the same thing time and again.
all results have been published. How
Kindly
can we
see.
affected?
Kindly see. Page 25. 1 minute.
Oh my God.
Pass the interim order.
Again, address to the court, don't indulge in inter-se argument.
Kindly see.
Address the court and maintain some decorum.
Flag F.
They're all designated senior counsels.
Flag F, page 25. For a minute, kindly see.
Flag F, page 25.
Page 25. This is a gate certificate, madam. Kindly see. If the gate certificate issued, it is valid for 3 years. It will remain valid for 3 years. Mr. Rotha yesterday indicated the notice that gate the syllabus. It is not a question mark highest mark out of 3. It is only gate score, valid gate score. If
So
someone
how you are affected?
applicant may not, this is
2021 candidate should go, my lord.
Yes. Who is
Their arguments are accepted, my lord. People who have a valid gate score for 2021, they would be eliminated. How? Yes, my lord. Because the gate score, therefore in the amendment they have used the word valid gate score. Present amendment, the present amendment as well as advertisement, they have used the word valid gate score. Meaning thereby, because valid gate score is used because the scorecard is valid for a period of 3 years. The candidates who have secured a valid gate score in 2021, they are eligible. 2022, they are eligible. 2023, they are eligible. But now they want to extend it to 2024, which is not the amendment.
So no, valid gate score.
After the rules,
In 2024, it will become invalid.
yes, ma'am. How? Because 2024 amendment is
valid for 3 years.
It's a gate rule.
but amendment.
That itself is discriminatory.
Is it the rule of the gate?
You are limiting it only 3 years.
In this case, they have to challenge the gate rules, my lord.
Page 25 again, valid
Show me that relevant provision. ଆଜ୍ଞା ଭୁଲାନ୍ତୁ ନାହିଁ ଯୋଉ ଗୋଟେ ପଏଣ୍ଟରେ କରୁଛନ୍ତି take it to a logical conclusion. ଅଧାରୁ ଛାଡ଼ି ଦେଇକି ଡିଆ ମାରନ୍ତୁ ଆଉ ଗୋଟେ point.
Your lordship, I can my intervention application.
No, that one I can 25 says 25. Page 25. That your lordship says that. Then page 25.
Your lordship, may kindly have my intervention application.
Page 25.
Let Mr. Tripathi conclude. Right.
If you lordship come to that page 25.
हाँ.
My lord, kindly see the Professor Ranjan Bhattacharya. Before that,
हाँ.
valid up to 31st March 2025.
Valid up to
31st of March 2025.
हाँ.
If it is extended by 24, will be invalid.
25 परा.
24,
No.
25 on the achiever.
हाँ. So it is valid.
2022. What my learned senior is showing, my lord, that particular document that was issued in 2022. Every valid, every
Valid up to 31st March 2025.
25. That's right.
So how you are affected?
It was issued by in 2021.
Huh?
It was issued by 2021. It was valid till 2022.
For 3 years.
That is, your lordship is going to interfere with the gate rules without having the
And that is very well when the rule was challenged.
unless and you don't challenge the rules, how can you
Just tone down your voice. Don't challenge the court.
PSC has
I
already
don't
passed
challenge
out.
the court. I never do that.
Any selection subject to result, OPSC already passed the order. It has already made the issue the corrigendum. हम तो corrigendum पर apply कर subject to हमें apply कर परिबुनी eligible to apply.
Whether the argument is completely misconceived and also misleading. The reference which they are drawing to para 27 is absolutely, there is no analogy at all. 27
Court and amendment was carried out because of division bench judgment matter. And that was the affidavit filed before the Supreme Court matter. The judgment was challenged. And the Supreme Court matter affidavit, state affidavit to have filed amendment. And that was accepted.
The body result upon that 27 was passed. That para 27 in reference to
2021, my lord. There the honorable court was of the view
that this candidate till 31st March 2024. Thereafter she has not appeared. She has not appeared.
she must not have okay, ma'am, paper.
This time she has not applied. हाँ.
3 ବର୍ଷ valid ରହିବ।
हाँ.
3 ବର୍ଷ valid ରହିଲେ 3 ବର୍ଷ ସରିଗଲା 24 ରେ।
हाँ.
ବର୍ତ୍ତମାନ you will be
ଏ ବର୍ଷ apply କରିନି.
ଗୋଟେ ଥର apply କଲେ ଦରକାର।
3 ବର୍ଷ ପାଇଁ
ଥରେ apply ହବ।
Correct, that is the requirement.
ଆଜ୍ଞା ଗୋଟେ ମିନିଟ୍ ଖାଲି ପାର୍ଟି ସମୟ କଲେ କଣ ହବ ତ ଟିକେ ଗୋଟେ ମିନିଟ୍ ଆଜ୍ଞା ପେଜ 157 ରିଟ୍ ପିଟିସନ ଟା ଦେଖି ଦଉନାହାନ୍ତି ତା ଦେହରେ ଅଛି ଗେଟ୍ ର ପ୍ରୋଭିଜନ ସେ ଦେଇଛନ୍ତି ନିଜେ ପିଟିସନର
157.
57 ପିଟିସନର କାଉନସିଲ ଦେଇଛନ୍ତି 596 ଟାରେ 2024 ଦେଖୁନାହାନ୍ତି ଲାଷ୍ଟ ବର୍ଟ ୱାନ୍ ଟା ଦେଖନ୍ତୁ ATE 2024 ସ୍କୋର
Yes, 157.
yes
You are referring to WPC 596.
596
हाँ.
ଦେଖନ୍ତୁ
88
स्कोर 2024 स्कोर कार्ड will
The
remain
highlights of gate 2024.
yes
हाँ.
এটা রিমেন valid যে 24
Which
ରେ apply
portion?
କରିବ
Which portion you are referring to?
it means last but 2
हाँ.
দেখুন ATE 2024
हाँ.
score card will remain valid for 3 years from the date of announcement of the result
हाँ.
सो 2024 रे जो माने अप्लाई कले ताकर 3 वर्ष सरियो 2027 रे जो माने 2021 रे अप्लाई करचंदी ताकर सरी गला ए 2024 रे सरी गला
So they have
तार गोटे
they have a chance.
I have given an example. I have given that. Now these persons, they will be, they have a valid score, they will be deprived of. And these people, because they have not appeared, now they wanted they should be inserted, and we should wait for them.
Are they saying that 21 was their best score and 22 and 23 are their worst score?
Concept, not a concept of
It
best.
only says our gate score.
Not a higher score.
It says our valid
Based on
gate
what
score.
in view of the amendment, concept of best or worst now goes.
That also means we are creating a class within a
No,
class.
no, we are not calculating class at all. You are not entered.
What else?
You have not appeared. But the fact remains, somebody might have not appeared the exam, have not appeared the examination, says that I will also apply for the post.
People who are being shut out
Everything should
and
be
before this score,
They have to appear and
They have to appear.
people who are likely to be shut out or before this score,
But then another
all right, I have noted your point. Tapre next.
more of a repetition.
मैं ଗୋଟେ ଖାଲି
ତାଙ୍କର ସରୁ
ମୁଁ ଆগে ଖାଲି ଦେଇ ଦଉଛି ନୋଟଟା ଦେଇ ଦଉଛି ନୋଟ
କଣ ନୋଟଟା
ଛୋଟିଆ ଡେଟ୍ ଚାର୍ଟଟା ନୋଟଟା କେବେ ହେଇଥିଲା କଣ ଖାଲି ପଏଣ୍ଟ ଆଉଟ୍ କରି କହୁଛି ଯେ ଆମର ଯଦି 2000 ଆଜ୍ଞା ଗଭର୍ଣ୍ଣମେଣ୍ଟ ଆଗ
you are for the interveners
ଇଣ୍ଟରଭେନର ଆଜ୍ଞା
supporting the state
ଆଜ୍ଞା ସପୋର୍ଟିଂ ଷ୍ଟେଟ୍ ଆଜ୍ଞା ତେତେ ଦେଖନ୍ତୁ ମୁଁ ଫାଷ୍ଟରୁ ଦେଇଛି କ୍ୟାବିନେଟ ପ୍ରଥମେ ଆଜ୍ଞା ଗୋଟେ ବିପି ଦେଲା ଗୋଟେ ମାନେ ପ୍ରେସ୍ ନୋଟ ଦେଲା in the year 10th December 2020 that we are going to insert gate system gate qualification. Now then recruitment 2021 and that was under challenge. Then 2022 gate means 2021 যেটা relate করছি that was available to them. They have not appeared. Then again আসলে clause number 6 କୁ ସେଥିରେ ହେଲା gate number 23 22 23 they have not appeared. Now third gate they wanted. Earlier they have an occasion to say that among the three where we have secured highest mark. Now by virtue of the amendment this has been taken away. Now question is they say that we will appear, whether they have already appeared or failed or not, that we do not know. They say that we will appear, kindly wait, and the day we get the score, then only you will hold the examination or recruitment. That is what is happening in the process. 2021 batch, they would be losing their chance.
all right next
I have given a detailed brief note concerning this final
all right
last portion.
next
So far the press ballot, it was widely published. So let's look at the press.
କିନ୍ତୁ ଆପଣଙ୍କୁ note file କରୁ I heard you file your note. Yes Mr. Rai,
3 ବର୍ଷ 3 ବର୍ଷ chance ପାଇଲେଣି.
any new point?
Yes, but my lord, new point, my lord, to add on, my lord, I have given already a citation, my lord, list of citations. Not you would find that in the record. But I'm directly covered by a judgment of the Honorable Apex Court. Your lordship will just kindly take that. That is State of Jammu and Kashmir versus Ajay Dogra. Your lordship may kindly see para 21 and 22.
Where is your note?
My lord, brief, my lord, I filed it, my lord, on the last date I filed it, my lord. On
Last date?
6/2/2024, my lord. Brief note of argument along with list of citation. My lord, got it, my lord?
Just a minute. IA number 942.
IA number 942, yes, my lord.
Yes.
My lord, State of Jammu and
State
Kashmir
of
versus
JK,
Ajay Dogra.
Ajay Dogra,
Yes, my lord.
BB Abhishek Raj.
Yes, my lord.
What
Your
should
lordship
I
refer to para 21,
Para
page
21.
14. Page 14. I'll just read out, my lord. The para 21, my lord. My lord, got it? The qualifications to be possessed by the applicants have been prescribed in the rules and also in the advertisement for the reason that some of them are required to be posted at high altitude and therefore they are required to have a proper physique so as to be able to be posted in those places. Para 22, my lord, in our considered opinion, the ratio of the aforesaid decisions of this court are squarely applicable to the facts of the present case. There was no challenge to the constitutional validity of Rule 176 of the police rules so far as it relates to prescribing physical conditions regarding the height and chest.
The stipulations in the advertisements regarding the standard of physical condition was also not challenged in the writ petition. The High Court was not justified in going into the validity of the aforesaid criterion in the absence of any such challenge. The High Court also has not specifically declared the rule prescribing minimum height standard and chest standard ultravirus, and therefore so long as the rule exists in the statute book, no such directions as issued by the High Court could be issued. Consequently, the directions issued by the High Court in the present case are required to be set aside. Besides this, my lord, now at the cost of repetition, may I just take my lord to para 27 of the judgment, which are so much harping upon. Then how this judgment is applicable? But this was in the background where the High Court has not declared the rule to be ultravirus.
Yes,
Here it was declared ultravirus.
No, my lord.
It's a scenario post declaration of ultravirus.
There was no challenge to the rules. Therefore, the honorable
Then the next judgment.
But the next judgment is on gate. This thing, I'm not placing that. But so far, in this judgment is concerned, my lord.
All right, we're relying upon this judgment only.
Yes, my lord. And now, my lord, your lordship would see para 27 of the judgment. Para 27 of the judgment.
There is no para 27. It ends with para 20.
No, para 27 of the judgment under Annex, which they're so much harping upon. But para 27 was in reference to the earlier rules, which came into force in January 2021. But there the requirement was, selection was supposed to be made. But I'm not reading the rules once again, but not to cut short. But there the requirement was selection on the basis of highest of valid gate score preceding 3 years, including the date of advertisement. There, this honorable court came to a finding that since the gate process had already begun in 2020, therefore the candidates who wanted to appear in 2021 couldn't have appeared. So therefore, the level playing field came into picture. The candidates of 2022 would be considered, 23 would be considered, but 2021 would be deprived. Then now, how far this is going to help them to show that even the 2024 people, the candidates who have not even appeared, none of us will know whether they have appeared or they wish to appear or what. But 2024 also should be extended. But by this process, 2021 candidates who have a valid gate score, valid gate score means because the validity is only for a period of 3 years. Therefore, they use this word valid, my lord. But now, by extending the benefit to 2024 candidates, my lord, 2021 they would be eliminated. Their validity would come to an end with 2023. So, so far as now, the cut-off date, my lord. The cut-off date is very much there in the advertisement, my lord. But no longer rest and declare that the candidates who have secured the qualifications by the cut-off date, they are eligible to apply, my lord. So therefore, my lord, they have in future they will apply. Suppose in case if they have a valid gate score. But at last, my lord. 27, man. So, this is all I want to say, man, and I have also filed a note of
you have filed your note.
I have filed my note. All right. One more aspect, my lord. One more aspect. I'm sorry, my lord. Now, virus has been challenged before the division bench. The virus of the rules, my lord, has been challenged before the division bench, my lord. The case number is WPC number 42059 of 2023. My lord, already the state has filed the counter. Matter is posted to next week for hearing, my lord. So, my lord, suppose, my lord, in this case, if there is any kind of interference, so far as the arguments of the petitions are concerned, my lord, that would be infructuous, my lord. That would be rendered odious.
How?
In what manner?
How that will be rendered infructuous?
Because over here, my lord,
that stands in a completely different footing.
Clause 5 of the advertisement.
Here they have not challenged the rules.
No, my lord, clause 5 of the advertisement, which is under challenge, my lord, it is same, my lord. It has been incorporated directly from the rules, my lord.
So let that be adjudicated. I am not standing in the way. Whatever will be decided, that will hold the field. I'll just pass orders after examining whether this is in consonance with the judgment of the division bench and the rules.
So only thing that 2021 candidates would be a different class is going to be created altogether. 2021 candidates, despite having a valid gate score, they'll be deprived. And whereas 2024 candidates who have not even appeared for gate.
All right, I have taken note of your contentions.
I am appearing in IR number 872 of 2024. I will draw my lord's kind attention page 157.
Repeat करो तुम.
I am not repeating, my lord. I am just showing another thing. Your lordship,
if you have anything new, then tell.
Yes, my lord. Page 157.
Yes.
From that paragraph starts from bottom. Candidates who currently, my lord. Lordship, got it?
Candidates? Who's
Candidate
current?
who currently studying in the third or higher years of any undergraduate degree program, or who has already completed any government approved degree program in engineering technology, architecture, science, humanities is eligible to appear in GATE 2024. That means before completion of the degree course, also engineering course, after completion of third year, they are eligible to appear. Even before getting the appearing in the final examination, they are eligible. And since 2021, even if that has been introduced, they are saying that we have not got the chance to appear. But so far as petition number 1 in this case, writ petition, my information is Sri Tarini Prasad Singh. He has completed his education in 2016, and in between also twice he has already appeared and could not succeed. That is my information I got from the
Succeed for what?
in net GATE examination.
Gate succeed on gate to खाली scoring
ସେମାନେ
succeed ako.
ତାଙ୍କର percentage ଅଛି।
Inter se merit ଟା ଖାଲି କରିବେ.
ଆଚ୍ଛା, your
It is not for any recruitment examination. It is just to test your merit. Inter se merit.
qualifying mark is there. Qualifying mark is there in GATE. And next your lordship may kindly see qualifying mark is there. I have enclosed my certificate that is at page 7 in my intervention application. Your lordship may kindly see qualifying marks they have been indicated. Page 7 of my intervention application.
कितने IA number?
IA number 872 of 2024.
Yes.
Your lordship may kindly turn to page 7.
Yes.
Towards the left side, your lordship GATE score 432, mark out of 100 37.04. Qualifying marks, your lordship may kindly take. Qualifying mark.
Gate score page 6-7 आपण दिटा ଦେଇଛନ୍ତି.
Sir, दिया है।
Series ଅଛି. Let us start with page 6.
दिटांकर अच्छे।
Page 6 रे ला
भी अच्छी।
gate score ला 708.
आया।
Marks out of 100. 63.27. Qualifying mark ला 29
Yes,
general.
qualifying mark is there,
SC ST 9.
for all. If somebody could not qualify, he cannot be eligible to sit apply for the post. Then
All right.
Then next point is now they are relying upon that annexure 6 that the judgment of earlier division bench. My humble submission, your lordship may kindly turn to page 43. Kindly turn to writ petition page 43. Subpara. So we have to decide whether the amendment of section 7 of the, this is the issue was for the honorable court.
Yes.
So we have to decide whether the amendment of section 7 of the Odisha Engineering Service Method Recruitment Condition Service Rules 2012 by Rule 4 of Odisha Engineering Service Method of Recruitment Condition Service 2021 insert such and such by substituting the method selection by OPSC on the basis of career marking, written test and viavos by highest GATE score obtained in the last 3 years preceding the advertisement is sustainable or is arbitrary, discriminatory and ultra vires.
Now କୁହନ୍ତୁ ତାପରେ କୁହନ୍ତୁ ପଢିଲି ସେଟା
Now, data has been quashed to 2021 rules and that has been para 28. The honorable board has taken the view, passed the final order, passing the amended rules, so also that advertisement. Subsequently, in 2023, that on the basis of further amended rules, this advertisement has issued. Even if they are now harping upon that paragraph 27 of that judgment and paragraph 28 of that judgment, ଚାଲିଛି ପୁରା।
ଦେଖିବି ଆଜ୍ଞା, ଦିଅନ୍ତୁ ମାର୍କ କରିକି ଦିଅନ୍ତୁ।
ହଁ ମୁଁ ଦେଇଛି ମାର୍କ କରିକି,
ହଁ।
ମୁଁ ଫ୍ଲାଗ ବି ମାର୍କ କରିଦେଇଛି। ସେଥିରେ ଏଥିରେ ଦ ଅନରେବଲ ସୁପ୍ରିମ କୋର୍ଟ ହାଜ ସେଡ୍
ହଁ
the legislature cannot by mere declaration without anything more directly overrule, reverse or override the judicial decision. However, it can, in exercise of the plenary power conferred upon it by Article 247 and 245 and 246 of the Constitution, render a judicial decision ineffective by enacting a valid law fundamentally altering and changing the condition on which the decision is based. My humble submission, even if that decision was there by the honorable division bench, subsequently by way of subsequent enactment, valid enactment, that order become inoperative. If at all they have any grievance in respect of that para 27 or they have not given the chance, they could have challenged that amendment itself because that advertisement is in consonance with the amendment. Amendment is in consonance with the rules, Milord. Therefore, Milord, without challenging the rules, they cannot challenge the advertisement which is in consonance with the rules. Then, Milord, another decision I am relying upon, your Lordship also kindly take note of para 14 and 15. I have given the mark, Milord. But here only the Honorable Apex Court has said that
in the state of Tamil Nadu.
Union of India versus Orlu Mochi, Inersu and others.
You can't rely upon this judgment. You can't read the name properly. You can't rely upon the judgment.
Your Lordship, paragraph 14 and 15. Before exam, your Lordship.
Yes.
Before examining the first limb of the question formulated above, it would be instructive to know, as a preface, the well-settled principle of law in the matter of applying precedents that the court should not place reliance on decisions without discussing as to how the fact situation of the case before it fits in with the fact and situation of
I have read this.
But here, the Honorable, that para 15, it has been said that observations are not the decisions, and that cannot be taken note of while deciding the.
All right. Next.
Lord, only one paragraph, Lord. I'll place, Lord, that judgment 142.
They don't note kari padi.
No, sir, say you judgment.
Padi say Euclid's theorem padi.
No, sir, unless.
Yes, state. Let us hear the state.
Okay.
Petition of the writ petition. हाँ.
सर लंच करके आता हूँ.
Yes. Page 40. 145. 144. Yes.
So what these goods may be called the Odisha Engineering Service letter of recruitment and the condition of service available to 2014. They shall come into force on the date of their publication in the Odisha Engineering. It shall come into force with effect from 26/9/2015. And later on published on 39. Gazetted on 30th September 2014. This has come into force with effect from 30th September 2014. But the rules say that you must say, the commission shall submit the candidates for the interview on the basis of merit and graduate aptitude to engineering gates to two times provided that candidate after receiving the calls are linked then to direct the process of merit and interviews. The merit is figured on the basis of
କୋଉଠି ପଢୁଛନ୍ତି ଏଟା 2-3 ଟା after receipt of all applications
the candidates on the basis of merit get score and the merit is figured on the basis of the candidates score in merit get score carrying 90% equal to carrying 10% to the test. But under 10% was not there. Only in 2021 that only 100% get score. Here by the 100 that 90 and 10. Then we were so there are advertisement and an extra. And you know, I from my notes out of my I have tried to
Phase 4. You have not filed any counter. Time କାଇଁ ଆପଣଙ୍କ ପାଖରେ ତ ବିଜି ସବୁ ଆପଣମାନେ ତ କାମ ଚଳିବା କଥା ଆଉ କଣ କାହାର ଗୋଟେ ଧରିକି କାହା ପିଠିରେ ଲାଗୁକି just a minute. Let me locate the counterpart. Preliminary counter affidavit by OP number 2, page 165. Yes. Which page?
Page 4.
Yes.
So the comparison of rule 7C and the cost height of the appendix. That the cost height of the appendix speak the selection procedure. That is in terms of the value. And they are not challenged, but they want to stabilize that. That is September 2023. They are not saying that it is not coming post because they are not challenged this. Once this rule has come into force, the amendment is made in accordance with the statutory rule. No amendment can be made without following the statutory rule. The terms and conditions of the amendment is in terms of the statutory rule. There is no deviation to it. This is the solution of it. And I consider that for one that high. Yes, पीछे पर इलेक्शन कमीशन This is a letter from the government. Yes. 20th fact letter, you have to be OPSC. Responsible. Letters from the government by the 27th July 2023. OPSC and General Hospital OPSC letter 31/7/2023 and There was message that next page of OPSC letter. Next proposal was submitted to the Opsc.
They suggested 70-30.
They submitted another proposal.
Flag C. 90-10.
90 days. The proposal to modify 10% and gets from the OPSC confirmed this proposal. 10%, 90%. Mark there that one the alerted to gate score, that was the alerted to gate score.
Flag, you are referring to flag
C mine.
C.
Gross message the proposed vector of statistical vectors can be modified to 10% and 90% alerted to gate score and the report to the bottom block. The gross message is that the gate because mentioned as gate score. Subsequently, OPSC clarified it to valid at fact D.
Yes.
That is valid gate score. The gate score may be treated as valid gate score. In accordance with the approval of the OPSC, this rule was amended on 26/9/2023 and it was gazetted on 30th September 2020. And in accordance with the statutory rule, the advertisement has been made.
All right.
And I will cite two reasons that advertisement made in accordance with the statutory rule. Second, the norm of the time of advertisement will government.
All right.
Only one line. Only one line. Can we come to page 154?
How often should you? You are only an intervener. You are good enough. Yes, OPSC, Mr. Manti.
Only 154.
Don't enlarge, Mr. Tripathi.
But only one.
Yes.
Only one page.
Let me hear first, Mr. Manti.
They just pick up the in the tune with the rules, exactly, as per that, the requisition was received from the government, and as per that, we have made there.
And you have given your concurrence to the rule, draft rule. That is there on record. So your argument is same as government, that it has been done in terms of the rules. All right.
Now the present rule is on the challenge the higher section. And then I have given the number because you are simple. That is
All right.
Only one page, 154 page. 154 of the read application. They have themselves find that. Understood. Let me check. Suppose.
ତାଙ୍କ କେସ୍ ଥିଲେ ସେ କାହାକୁ କହିବାକୁ ଦେବେନି ମିଷ୍ଟର ତ୍ରିପାଠୀ
Then ମୁଁ ଆଜ୍ଞା ଅପେକ୍ଷା କରୁଛି. So this is the one aspect and what I am so judgment is there. This is the employer not correct.
That is correct. Nobody disputes that.
6. This is it.
That's the settled position of law. If you want, I can take note of it.
So the ineligible candidates, if supposing they are given some premium, but this amounts to,
It is not, Mr. Manti, again you are making a mistake. It is not a question of ineligible candidate. I am examining it from the angle they are arguing, para 27, of providing fair opportunity to all. You have to justify that you have provided fair opportunity to all. That's the limited point in this case. Nothing more. And nobody is going to the virus of the rule which is pending for the division bench. So, their main argument is they have not been provided with a fair opportunity. That you have to counter.
they are not in the equal. But the not kindly take it for example. going to internship and now this MBBS they are saying that even though we don't have the internship, then we maybe have. So the whole that internship is time to time every year admission is taken.
That is a basic eligibility requirement, Mr. Manti. That's a basic eligibility. Here it is a test enters a merit of the candidates. You have adopted a particular method of selection.
Yes.
It is not that they don't have the basic eligibility criteria. They are holding those engineering graduate degree. Only thing is that how they are to be selected.
Admission is every year.
Right. So that is what basically assessment of enters a merit of the candidates.
That is
So it can't be equated with that MBBS, the reference you cite.
candidates having the
In the absence of that internship certificate, that basic degree becomes invalid. So they become ineligible. So here it is not a question of ineligibility. Here it is a recruitment test.
Right. But one thing that become eligible. The person having the graduation in engineering with gate score only will be eligible.
Right.
They are the candidate, they don't have the gate. So that is why they cannot be at the same bar with the other candidates having the gate score with the engineering thing. So that is why there is no violation of Article 14.
All right.
Only 154 page, only one page. Page 154. It was a corrigendum issued by PSC. Page 154.
Yes.
It was, kindly see the first paragraph. It was indicated that the read application has been challenged, the rule was challenged in that read application and person to answers is subject to final orders of the Honorable High Court. So when it was made subject to, why will a separate application to be filed and decided in that's my case. And they have filed this document because within their knowledge that anything that is to be happen in terms of the advertisement is subject to final outcome of the read application. If it is ballot, any order is passed, in this case also ballot, is also subject to division bench judgment. Clear. So the read application is premature according to us.
But last thing ballot. But last thing ballot. Only for the purpose of reiterating ballot. Suppose
Don't reiterate. I remember everything.
my only humble submission ballot. Suppose 2024 candidates would be allowed.
Suppose or
But at 2021 the candidates would be eliminated. You know, may only keep this in mind.
right. As you argued that, I have taken note of that point. That's a very valid
I'm
point.
only afraid ballot.
That's a very valid point.
That's a very yes ballot.
ইয়ার ছেড়ে বলছেন পুরো
Correct. 2021 যে পাস করছে গেট that is valid till 2023.
যা বুঝা নোট ফাইল করা আছে বাই টুমরো দিদি পেজ নোট দিয়ে দিও
सर ठीक है 1 2 3 1 टे
1 2
3 1
হ্যাঁ 1 2 3 1 কোন রিড
जी हां
দেলে কাটলে
12 केस्टर सर इंटरवेंशन करछे एटा भी सेम स्टेटस इश्यू नोटिस हेतला सो तो से काइंडली टर्न टू पेज 163
পেজ
163 এই যে পিটিশনার পিটিশনার হচ্ছে নেম ইজ সালিনা সমরিত সামল they also kindly see GATE graduate aptitude test in exam engineering 2024 admit card because she has applied admit card when the 4th February 2024 is Sunday examination the result will be published in the month of March but she is deprived of now making to participate in the to make an application his application will be rejected am I clear? Annexure 10 163 a candidate with a petition in this case she has applied
earlier she has not appeared in gate
yes they have not appeared and he got the opportunity the admit card was issued and examination was held result has not been published ମୁଁ ଆଉ ଫର୍ଦର କିଛି ଯିବାକୁ ଚାହୁଁନି ଏମାନେ ସବୁ ଆଗରେ ଆଉ ରିପିଟ୍ କରିବାକୁ ଗୋଟେ ଚାହୁଁନି
all right
ଆଉ କାହିଁକି କହିବା ରିପିଟ୍ କରିବାକୁ ମୁଁ ତ ସେଇ ଗୋଟିଏ କଥା ଦିଟା ଡେଟ୍ ହିଁ କହୁଛି whether we got the fair opportunity to appear in the exam because
ଆପଣଙ୍କ ପଏଣ୍ଟ ଏକା ମୁଁ କ୍ରିଷ୍ଟାଲାଇଜ କଲି
ସାର୍
ଆପଣଙ୍କୁ ଭଲ ଲାଗିଲା ନା ନାଇଁ ମିଷ୍ଟର ତ୍ରିପାଠୀ ଭଲ ଲାଗିବନି ତାଙ୍କୁ ମୁଁ ବାରମ୍ବାର କହୁଛି ଆଜ୍ଞା ଟେକ୍ ନୋଟ୍ ଅଫ ଦ ପଏଣ୍ଟ ମିଷ୍ଟର ରାୟ ଇଜ ଗୋଇଂ ଅନ୍ ଆର୍ଗୁଇଂ
ଆଉ କିଛି କହିବା
ଦେୟାର ଅପରଚ୍ୟୁନିଟି ଟୁ ଅଲ୍
କିଛି ଲାଭ ନାହିଁ
ହଁ କାଲି ସୁଦ୍ଧା ଦିଅନ୍ତୁ ଦିଦି ହଁ ତାପରେ ନେକ୍ସଟ କଣ 3ଟା ବେଳକୁ ଗୋଟେ ଫିକ୍ସ ହେଇଥିଲା ବା
ହଁ ସାର୍ ଖାଲି ଗୋଟେ ଜଜମେଣ୍ଟ ଟା ଦେଇଦଉ ସାର୍
ଆପଣ ନୋଟ୍ ସାଙ୍ଗରେ ଦେଇଦେବେ
ଖାଲି ପଦଟେ କହିଦଉଛି ସେ
ହଁ।
2004 ର ଜଜମେଣ୍ଟ ଟା
ହଁ।
even if a relief is amounting to granting of final leave can be granted at interim stage if the lordship feels that they finally that there will not having left
ଆମେ ଯଦି ଇଜି ମଡେଲ ନହବ ଆମେ ଆପ୍ଲିକେସନ ପକେଇ ପାରିବୁ ଆପଣ ହିୟରିଂ କଲେ ବି ଆମ ଆପ୍ଲିକେସନ ଇନଫ୍ରାକ୍ସନ ହେଇଗଲା ତାଙ୍କର କିଛି ହବାର ନାହିଁ ବର୍ତ୍ତମାନ
ବାସ୍ ସେତିକି ହେଲା
ଆଉ ଆମର କଣ 2012 ରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ ଆମେ ଏଲିଜିବଲ୍ ଥିଲୁ ବର୍ତ୍ତମାନ ଇନଏଲିଜିବଲ୍ ହେଲା ମାନେ ଆମେ ଥ୍ରୁ
ଆଉ ultimate decide କରିବେ ଯେ eligibility must be on the date of advertisement
ସେଇଟା
ସେଇଟା sir।
2021 ପିଲା ଏପଟ ତଳ କୋଟ ଏଲିମିନେଟ୍ ହେଇଛି 2024 ପାଇବେ 2021 ଏଲିମିନେଟ୍
2024 17 ଟା ହେଲେ apply କରିବେ
2024 ଆଗକୁ ଯୋଉ vacancy ଆସିବ କିନ୍ତୁ କ୍ରିଏସନ ହବ 27 ପାଇବେ 27 ପର୍ଯ୍ୟନ୍ତ ପାଇବେ ଏମାନେ ପୁରା ଟୋଟାଲି ଡିପ୍ରାଇଭ୍ ହେଇଯାଇ ସବୁ
ହଁ ଅର୍ଡର ଦେଇଯାଉ
Yeah, please, ma'am. That's in this writ application. Petitioners were during course of discharge of duties by the